pay CRW the adjudicated sum. PGN served a notice of satisfaction. And in 2009, CRW sought to enforce the decision without referring the merits to arbitration. So sought to enforce in the courts. Sorry, sought to enforce in arbitration. The arbitral tribunal by majority issued a final award enforcing the decision. The High Court in Singapore set aside the award, and the Court of Appeal upheld that judgment with an endorsement that it would be permissible to enforce provided the merits were also referred to the same arbitration. In 2011, pursuant to the Court of Appeal's guidance in that first decision, CRW started arbitral proceedings, this time seeking to enforce the DAB decision in interim award as well as referring the merits to arbitration. Again, there was a majority award enforcing the DAB's decision. This time, both the High Court and the Court of Appeal agreed with the arbitrators. In his 64-page judgment, Chief Justice Menon held that the interim award ordering PGN to pay CRW and the lower court's order granting CRW leave to enforce the interim award would be treated in the same manner as a court judgment. The Court of Appeal emphasized that it may be vital that the parties comply with a DAB's decision, and it's of general importance that contractors are paid promptly where the contract so provides. It summarized its interpretation of the effect of the notice of satisfaction on a DAB decision by holding that a DAB decision is immediately binding once it's made. The parties are obliged to give effect to it promptly until such time as it is overtaken or revised by either an amicable settlement or a subsequent arbitral award. And a notice of satisfaction does not and cannot displace the binding nature of a DAB decision or the parties' concomitant obligation to promptly give effect to and implement it. Clause 20.7 addresses a failure to comply with a DAB decision. This subclause provides that if neither party gives a notice of satisfaction, the decision becomes final and binding, and if a party fails to comply with it, then the other party may refer the failure to comply straight to arbitration. Clause 20.8 deals with the expiry of the dispute board's appointment. This subclause provides that if a dispute arises and there's no DAB in place, then subclauses 20.4 and 20.5 shall not apply, and the dispute may be referred directly to arbitration under subclause 20.6. It says whether by reason of expiry of the DAB's appointment or otherwise, the issue when if a party may go straight to arbitration without appointing a DAB has been the subject of much judicial debate. In the English High Court, in the Dawson Babcock Limited against Commerciary de Equipidos, the case concerned a modified form of the FIDIC Red Book. Mr. Justice Edward Stewart was asked to issue an interim injunction to restrain MABE making a demand under 2 performance guarantees, which it did. As there was no DAB in place, the standing DAB not having been appointed within the prescribed 42-day period, the parties were entitled to refer the dispute directly to arbitration. Consequently, Dawson undertook to issue a request for arbitration under the ICC rules as soon as reasonably practicable. In the English case of Peterborough City Council against Enterprise Managed Services I referred to earlier, a case under the FIDIC Silver Book, Mr. Justice Edward Stewart again thought there was a significant distinction between the FIDIC Red Book, which required a standing DAB, and the Yellow and Silver Books, which provided for ad hoc DABs. Here, he held that where a dispute arises with only an ad hoc DAB, then the parties had to attempt adjudication prior to commencing an arbitration. The point was made that as a dispute would always arise prior to the appointment of the DAB, where it was ad hoc, then if there was no obligation to use the DAB, the whole process would be circumvented. And Mr. Justice Edward Stewart held that it seems to me that subclause 20.8, which is in the same in all 3 of the FIDIC books, probably applies only cases where the contract provides for standing DAB rather than the procedure of appointing an ad hoc DAB after a dispute has arisen. He went on to reject the submissions that subclause 20.8 gives a party a unilateral right to opt out of the DAB process. He stated that the contract requires that the determination of the current dispute is by way of adjudication and amicable settlement under subclauses 20.5, 20.4 and 20.5, saying that by litigation. That's the end of my slides, end of my talk. That's been a very fairly quick run through the provisions. I hope all of that was clear, and I'm sure if any questions, we can deal with those as they arise. Thank you.
Yeah. Thank you very much, Abdul. There's two questions that I'd be curious to have your thoughts on. They're related. The first is and both relate to the 84-day time limit.
Yes.
Yeah. So in your experience, have you found that 84 days is enough to rigorously and thoroughly get to issues generally? And the second is, what are the common amendments you've seen to this clause? I mean, increasing that 84 days or reducing it, shortening the timeline?
Yeah. It very much depends on the project. It's in my experience, very rarely has a DAB been able to complete its work in 84 days. And the parties generally adopt a commonsensical approach to this and will give the DAB such extensions of time as requires to get to the bottom of the issues. This particularly so, given that there's an increasing trend to turn DABs effectively into mini arbitrations. So parties essentially want to go through the full gamut of case management procedures leading into a hearing, and that's very, very rarely possible within 84 days. By and large, you need more time. 180 days is in my experience, is the more usual sort of timescale for a DAB in a project of any size. Now, clearly, there may be certain issues that come up that are fairly small, fairly discrete, that can be dealt with quickly, but by and large, you need more than 84 days. And in terms of the common amendments that one finds, it is usually to either stipulate a much longer period or to leave it up to the dispute board to determine how long it requires to deal with issues. So removing that 84-day guillotine that's on the dispute board.
Thanks very much for that, Abdul, and for your presentation and for addressing these questions. We now break for 10 minutes, after which we will reconvene and hear from John on amicable settlement and arbitration. Welcome back, everyone. Following Abdul's excellent presentation on DABs, we now move to the next step with John, who will walk us through both amicable settlement and the step after arbitration. John, would you please?
Thanks very much. And as you say, I'm going to concentrate on the next two steps in the dispute resolution procedure. So FIDIC contracts have what gets called a multi-tier dispute resolution procedure. So you need to progressively move through a number of steps if you aren't able to resolve your dispute at the earlier stage. So dispute boards are covered using the FIDIC Red Book numbering by subclause 20.4. Then you move on to amicable settlement, which is subclause 20.5, and then arbitration if you're unable to settle your dispute, and that's subclause 20.6. And I'm going to take these issues in the order you see in the slide there. So first, amicable settlement. I've extracted the provision from the FIDIC Red Book on the slide. I'm not going to read it out, but you can see there, I think, that this provision contains three concepts. The first is the notice of dissatisfaction, referred to in the first clause of the provision, because you only proceed to this step in the dispute resolutions process if there's been a notice of dissatisfaction. I'll explain what that is in a second. Then also in the first sentence of the provision, there is a mandatory, there's an obligation to attempt settlement. So once there's a notice of dissatisfaction, the parties have to try to get together and resolve their dispute amicably. And then in the final sentence of the provision, there's a related but distinct concept, which is the 56-day cooling off period. So whether or not you try and settle your dispute amicably, you need to wait 56 days before you can commence arbitration. So I want to look at those three concepts in turn. First, the notice of dissatisfaction. So remember, by this stage, you've already gone through the dispute board process and you've received a dispute board decision. Now, if either party wants to challenge that dispute board decision, they need to issue a notice of dissatisfaction within 28 days. If no notice is issued, then the DAB's decision becomes binding and you can't challenge it thereafter. And if there is a notice, then you proceed to subclause 20.5 and an attempt at amicable settlement. Now, there are formal requirements, albeit relatively limited, for a notice of dissatisfaction. It has to say that it's given under subclause 20.4. It needs to set out the matters in dispute, and it needs to provide the reasons for a party's dissatisfaction with the dispute board decision. Now, it's my experience that following the decision of the dispute board, these notices are issued as a matter of course. It's almost invariably the case that at least one party is dissatisfied with a dispute board decision, and so it preserves its right to challenge that decision by promptly issuing a notice of dissatisfaction. I should say there has been a revision to this provision in the 2017 Red Book. The 2017 Red Book allows you to issue a notice which indicates which parts of the dispute board decision you're dissatisfied with, which leaves open the possibility that the remainder of that decision not being challenged might become binding. But that isn't, or at least isn't clearly an option under the 1999 Red Book. Once there's been a notice of dissatisfaction, subclause 20.5 imposes a positive obligation to try to settle the dispute. What it doesn't do is set out any requirement as to form. So it doesn't say you have to mediate. It doesn't say you have to negotiate. The parties can choose whatever form of amicable settlement they like, however informal. On the face of it, it would appear to be enough to satisfy this clause to ping an email over to the other side saying, please, can you spare a few minutes to talk this matter over on the phone and see if we can come to a resolution. One question that arises from this is what happens if you don't attempt to settle the dispute? Well, practically, maybe nothing. After 56 days, whether you've made an attempt to settle or not, you can proceed to arbitration. On the slide there, I've mentioned the Emirates case, which Abdul actually also referred to. It holds open the possibility that if a party breaches this clause, they might become liable in damages. It suggests that you might be able to obtain damages for loss of a chance, the premise being that there was a chance you might have settled it had a party complied with its obligation to attempt settlement. Although that possibility is floated in the Emirates case, it seems like a tough claim to me. It seems challenging to be able to establish that you had a reasonable chance to settle a dispute in 56 days if one party appears to have set their face against it. Nevertheless, it may not be the case that you can ignore this kind of provision with impunity. As I mentioned, there's a related requirement in subclause 20.5 for a cooling off period. So whether or not you attempt to amicably settle your dispute, clause 20.5 says you need to wait 56 days from the notice of dissatisfaction until you commence arbitration. On its face, that looks like a relatively simple provision that shouldn't cause anyone any difficulties. However, not so. There's an arbitration practitioner called Gary Bourne, and he has written an article on this subject called A Dismal Swamp, because there is a ton of conflicting case law about the effect of these provisions and how they operate. The problem is as follows. Parties breach these provisions relatively frequently. They either just get impatient, or they think there's an advantage in being a claimant in an eventual arbitration, so they want to start the arbitration first, or discussions break down and they think it's pointless to wait 56 days, and so they start arbitration early. And the question is, if you start arbitration early, what happens? And across the arbitration world, and particularly in the context of bilateral investment treaties, there's a lot of conflicting authority. The controversy is whether a provision like this acts as a condition precedent to an arbitration agreement, such that if a party fails to comply with it, the arbitral tribunal won't have jurisdiction. And if a cooling off provision is interpreted in that way, it can have really drastic consequences. It can mean, for instance, that if a party commences arbitration prematurely, but an arbitral tribunal nevertheless proceeds to issue an award, then that award is unenforceable at the end of the day because the tribunal didn't have jurisdiction. And in that way, years of time and millions of dollars can be wasted. And I, in fact, was involved in a case where a party tried to resist enforcement of an arbitral award worth hundreds of millions of dollars because a party started an arbitration prematurely without waiting the full length of a cooling off period. Now, almost all academic opinion and an increasing number of authorities suggest that's the wrong way to interpret these clauses. And instead, it's suggested that cooling off periods are a procedural requirement or something that goes to what's commonly known as admissibility. In short, that means it's up to the arbitrators to decide the consequences of non-compliance with this kind of clause, but it doesn't deprive the arbitrators of jurisdiction. And you can see an extract from Gary Bourne's book on arbitration endorsing that kind of approach. And it was recently endorsed by the English courts in the Republic of Sierra Leone case that I've referred to in the slide. But as I say, these provisions are treated in very varying ways across jurisdictions. So you really need to check the local law to see how it's likely that they'll be treated in the jurisdiction where you're operating. There are a couple of lessons from this. One lesson is, if there's a cooling off period in a FIDIC contract, just wait your 56 days before you commence arbitration. It isn't hard. There's a different lesson, I think, that in many contracts like the FIDIC one, parties pack their contracts with multiple steps to avoid disputes. But in certain circumstances, those steps can create their own disputes. In other words, the road to hell is paved with good intentions. So whenever you're negotiating a contract, it's worth considering whether you actually need this kind of multi-tiered approach to dispute resolution, which can cause problems as well as avert them. So you've waited your 56 days and you can finally go to arbitration. On the slide, I've extracted the rather lengthy arbitration agreement from the FIDIC Red Book. Now, when a notice of arbitration is issued, it's a happy day for lawyers. We need to eat after all. But it's a profoundly depressing day for everyone else. You need to think about the stage you've reached here. By this stage, you've already spent considerable time and money arguing the dispute before the engineer, arguing the dispute before the dispute board, attempting amicable settlement, and now you've started arbitration. So you need to spend considerably more time and money over a period of years often, arguing the dispute again in arbitration. By this time, people want to go home and forget about the project, but instead they're going to have to relive the same dispute for years to come. Now, arbitration is a vast topic. People do degrees in it. So today we can only really scratch the surface. And one thing to say is that there's no magic in the FIDIC arbitration agreement It's a fairly conventional agreement. And if you've done a construction arbitration, then the FIDIC arbitration agreement probably isn't going to throw up any particular surprises. I'm going to start with some basics, and apologies if for many of you this goes over familiar territory. Now, arbitration, unlike some means of alternative dispute resolution, results in a final and binding decision. An arbitral award can be enforced internationally under the New York Convention. The New York Convention is, without question, the most successful instrument of private international law that's ever been conceived. 172 countries have signed it, and for those signatories, it commits them to enforcing arbitral awards within their jurisdiction, except in very limited circumstances, such as where an arbitral tribunal had no jurisdiction, or there was a failure to observe due process, or enforcing the arbitral award would be contrary to the public policy of the jurisdiction where enforcement is sought. And the effect of the New York Convention is that it's considerably easier to enforce an arbitral award internationally than it is to enforce the decision of a national court. If you actually pull up the text of the New York Convention, one of the things you'll realize is that it's not very clearly drafted. And in that sense, it's a victim of its own success. It's just impossible to get 172 signatories to agree changes in the text of the treaty. So one perceived advantage of arbitration is its finality. A second that's particularly relevant from the perspective of FIDIC is the neutrality of the process. If you're a contractor, you might not be keen to submit your disputes to the local courts of the employer, for instance. There's a sense that local courts might favour local parties. And the fear there isn't just one of bias, though I think there is that fear. The fear from some contractors is being dragged into a legal culture and a set of legal processes that are unfamiliar. In arbitration under the FIDIC contracts, there's a tribunal of 3 arbitrators, and each party generally gets to pick one of the arbitrators. Similarly, the arbitration is often seated, a concept I'll come on to discuss in a second, in a neutral third-party country. This isn't invariably the case, though. With major infrastructure projects, the employer will often exercise considerable bargaining power during negotiations, and an employer might insist that arbitrations are conducted locally under the local rules of an arbitral institution. And that just depends on bargaining powers of the party where that negotiation ends up. Another, again, perceived advantage of arbitration is that it's confidential, or at least mostly confidential. It really depends on the law governing the arbitration agreement and the applicable procedural rules. Under English law, a term is implied in arbitration agreements that the proceedings are confidential, but there are numerous exceptions. So public companies will have public reporting duties that might require them to disclose at least the existence of an arbitration and its value. State entities often have duties of transparency. So while it's often stated that arbitration is confidential, the concept of confidentiality in arbitration is somewhat moth-eaten. But it's still probably fair to say that there's less publicity associated with an arbitration than there is with court proceedings. On this slide, I've set out some drafting considerations. There are some aspects of arbitration that the FIDIC contracts are silent about, and there are some aspects of arbitration that are quite frequently amended within the FIDIC contract. So one thing the FIDIC contract doesn't address is the seat of the arbitration or the place of the arbitration. Now, when one refers to the arbitral seat, it's a reference to the procedural law that will apply to the arbitration and the court system that will oversee the arbitration, and in certain circumstances, which will have the power to annul any eventual arbitration award. So for instance, if an arbitration is seated in London, that means the provisions of the English Arbitration Act will apply to that arbitration, and the English courts will oversee the arbitration. There's a university in London called Queen Mary's, and it runs an arbitration survey every couple of years among business users of arbitration. And it says that the most popular seats these days are London, Singapore, Hong Kong, Paris, Geneva, and New York, in that order. And that's a fairly stable list of jurisdictions, with Singapore moving up the rankings over the year and Paris dropping down slightly. The seat is often chosen for being a neutral jurisdiction with a history of light touch regulation of arbitration by the courts. Again, by the time you reach arbitration, you've already argued before the engineer, you've already argued before the dispute board, you've spent years arguing in arbitration. The last thing you want is for the national court to open it up again and to force the parties to argue the issue once more before the national courts. So that's why I say generally the preference is for light touch regulation of arbitration. But there's a balance to be had. In the 1980s, Belgium introduced arbitration legislation, which for foreign parties didn't allow them to challenge arbitral awards before the Belgian courts for any reason at all. And that was largely regarded as going too far. So you want light touch regulation of arbitration by the national courts. You don't want no regulation at all. Sometimes the place or venue where an arbitration is held is the same as the seat. That's not invariably the case. You can have an arbitration that takes place in London but is seated in Singapore. And when choosing a venue or a place for an arbitration, considerations of convenience come to the fore. The question that arises is, how easy is it for parties to get there? Can they get a visa to that jurisdiction? Are the legal representatives there? Do they have good facilities? And even, is it a nice place for a holiday once the hearing's finished? Which is a consideration in a number of arbitrations I've been involved with. Another question is the arbitral rules. That is the high-level procedural rules that apply to an arbitration. Under FIDIC, the presumption is the ICC rules unless you change it. But the provisions sometimes amended to provide for the SIAC rules, or the HKIAC rules, the LCIA rules. Once an arbitration is up and running, it's questionable whether it makes that much of a difference what procedural rules are chosen. But it matters more at the start of proceedings, when the time periods for responses and so on are different between the different sets of rules, and where the different sets of procedural rules grant arbitral institutions different powers for consolidating arbitrations together, or providing for the early determination of claims, or for providing for expedited procedures. Often parties choose the arbitration rules that are local at the seat of the arbitration. So in a Singapore seated arbitration, you might choose the SIAC rules. But again, that doesn't have to be the case. You can perfectly easily have an ICC arbitration seated in Singapore. The last consideration I've listed there are nationality and expertise requirements. Sometimes the parties will specify in an arbitration agreement that their arbitrators must be or shouldn't be of a certain nationality or must have a certain type of expertise. Many types of arbitral rules, including the ICC rules, already have a policy that the chair or president of the arbitral tribunal won't share a nationality with either of the parties. But sometimes parties make provision for that in any event. It's more rare to specify that an arbitrator has to have a specific set of expertise, largely because that narrows the pool of arbitrators that are available. But sometimes parties will say that the arbitrator must be an engineer or have specific language skills or perhaps certain sexual experience. Next, arbitral procedure. Now, arbitration is an inherently flexible process, and that makes it hard to speak meaningfully about what arbitral procedure is at a level of generality. One FIDIC arbitration isn't necessarily the same as the next. On the slide, I've set out a provision of the UN model law. Many countries have adopted the UN model law as their arbitral legislation, and almost all countries' arbitral legislation has at least been influenced by the UN model law. And you can see how broad the provisions of that law are regarding arbitral procedures. In essence, arbitral procedure is whatever the parties agree it to be, or in the absence of agreement, whatever the arbitral tribunal decides it is. And arbitral rules like the ICC rules go some way in fleshing that out. But an arbitral tribunal still has considerable freedom to decide whatever procedure it thinks is appropriate for the dispute before it. My experience is the single biggest determinant of what procedure is followed isn't the applicable arbitral legislation. It isn't even the applicable arbitral rules. It's the legal background of the party's legal representatives and the tribunal. So, for instance, if the party's legal representatives are English barristers and the tribunal is made up of former English judges, then guess what? Your arbitration is going to look quite a lot like an English court proceeding. If the party's lawyers are all Swiss arbitrators and the tribunal is made up of Swiss or civil lawyers, then the proceeding is going to look very different. So I'm wary of saying what a construction arbitration looks like or what it should be. I will say that among English lawyers, at least, there's a tendency for construction arbitrations to get very big. That means often thousands of pages of submissions leading to a 3 or 4 week hearing and an award running to many hundreds of pages. But that's not inevitable. And many clients won't agree that that's a sensible use of resources. I've done a $200 million final account dispute that only lasted for a 4.5-day hearing. That meant that some points received less scrutiny, and there was some risk that the tribunal wouldn't grasp the nuances of everything that was in dispute. But was it a possible way of resolving that dispute? Yes. And might some clients think that more streamlined procedure is preferable? Again, I think yes. So it's always necessary at the start of a dispute to think practically about what is the best way for this dispute to be resolved, and not just to drag out the procedural order from an arbitration you've done in the past. Each time you should try and consider it afresh. There's not a single procedure that is suitable for every arbitration. Finally, I've set out some common procedural questions that arise in arbitration. Some of these are more theoretical than real. So the first question I've set out there is whether arbitrators will follow an adversarial or inquisitorial process. In an adversarial process, the facts are established through oppositional arguments between the lawyers. There'll be cross-examination as a means to establish the facts. An inquisitorial process is more common in civil law jurisdictions, and it involves the arbitral tribunal in a greater role in ascertaining the facts. They'll take a more active role in asking witnesses questions and in directing the parties to provide evidence. Every arbitration I've done has been adversarial. I used to work in a law firm with a number of civil lawyers, and every arbitration they did was also an adversarial process. So although this is a common talking point when it comes to arbitral procedure, my experience is that the common law approach, the adversarial approach, is the dominant one in arbitration, and especially in construction arbitration. Pleadings versus memorials is a more minor issue that arises at the start of an arbitration. When I say a pleading, I mean a kind of bare bones document that sets out the key factual propositions on which a party's case relies without legal argument and without evidence to support it. When I say a memorial, I mean a fuller statement of a party's case, which includes legal argument and is generally accompanied by all evidence on which a party relies. In my experience, bare bone pleadings are quite rare in arbitration. Most parties prefer to put in a fuller and less formal statement of their case. My own view is that if witness evidence and expert evidence follows the initial submissions, the evidence tends to be of a higher quality. There's more time to prepare it, and the issues are better defined by the time the evidence comes to be submitted. On the other hand, if you follow a memorial procedure, that generally means fewer procedural steps, and it can save some time in the procedural timetable. So I think there's merits in both a more pleadings-based approach or a more memorial-based approach, and it really depends what you're trying to achieve. Formal rules of evidence don't generally apply in arbitration in the same way as they would before national courts. In arbitration, I haven't encountered people making, for instance, applications to exclude hearsay evidence, but those applications are generally given fairly short shrift by the arbitrators. there are a number of soft law instruments or guidance documents which might help, which are sometimes adopted in arbitrations to give some guidance to the parties and to the arbitral tribunal on how they should approach questions of evidence. By far the most common set of guidelines that are adopted are the IBA rules on the taking of evidence in international arbitration. And they're just very high level guidelines on how a tribunal might approach issues of witness evidence, expert evidence, and disclosure. There's a perception that the IBA rules are oriented towards a common law approach towards evidence. So a few years ago, there was a group of civil lawyers that published a competitor called the Prague Rules, which was an attempt to rebalance things more towards a civil law approach towards evidence. When the Prague Rules were released, there were a very large number of academic articles written about the impact they might have. I've never encountered the Prague Rules in the wild, and I would bet that the vast majority of arbitration practitioners have never heard of them. So the IBA rules of evidence remain far, far more common. Finally, the last issue I've raised there are the rules of professional conduct in international arbitration. There's an academic called Catherine Rogers who writes about this topic frequently. And she, in a resonant phrase, characterized international arbitration as an ethical no man's land on the grounds that there's no one set of professional conduct rules that applies to all lawyers acting in international arbitration. That might overstate things, but it's something to be aware about if you are acting in an arbitration against lawyers who come from a different legal background. For instance, US lawyers prepare their witnesses to give evidence to a far greater degree than might be considered appropriate in other jurisdictions. It's just a different background. So if you're preparing a cross-examination, that's something you need to be aware of. A few years ago, the Swiss arbitration institution, the ASA, did some research into this, and they wanted to set up a framework that would apply to all lawyers in international arbitration. But they found that there was actually little appetite among lawyers for a system that would require them to lodge complaints against their colleagues. So for now, the ethical no man's land is here to stay. So that's a whistle-stop tour of arbitration, but I'd be very happy to answer any questions about it if there are any from the audience.
Thanks very much, John. That was an excellent presentation, especially going through the FIDIC provisions as well as just refreshing everyone on how an arbitration works and procedurally the framework that applies to it. So there's two questions we'd be grateful to have your thoughts on. The first is to do with procedure, right? What you've done a lot of general commercial arbitration and specialized construction work. So have you seen, or do you have any thoughts on how case management, document management can be done in such a way that it keeps the documents lean? Because construction projects generate a lot of documents, but have you seen tribunals tailor their procedure based on the dispute? For example, if there's a very simple dispute like progress payments have not been made, ideally you just want progress certificates and payment records. Not.
My experience with construction arbitration is that people tend to save disputes up. So with dispute boards, you get narrow issues going to dispute board where they're asked to decide on one progress payment and so on. But by the time you get to an arbitration, parties have usually collated a bunch of issues, and quite often they'll wait till the end of the project to throw everything into arbitration. So by that point, the prospect of keeping things lean is often out the window, and you'll have these huge arbitrations which undo all the good work that's been done in the dispute board and keep lawyers busy for many years while the parties tear their hair out. But it's very difficult to keep construction arbitrations lean. One of the reasons for it is that parties are very reluctant to fight arbitrations with all with claims going in only one direction. So if there's a claim against you in arbitration on one discrete issue, parties usually try and throw in some of their own claims to make weight, so that both parties stand to gain or lose something in arbitration. But this has the inevitable effect of the dispute snowballing, so it gets bigger and bigger and bigger. So it is difficult, but you do find that if you have a civil law trained tribunal, they might be less sympathetic to the common law view that arbitrations need to be big, and things can be decided in shorter hearings with shorter procedural timelines. From the lawyer's perspective, you just do your best in the time available, but that requires a lot of discipline from the tribunal. My experience is it's hard to keep construction arbitrations lean.
Right. Thanks, John. I suppose a related question comes up from something that you said. And indeed, parties do wait for everything to snowball before they are willing to consider arbitration. My question would be, what are your thoughts on that? Have you seen, arbitrations very much which happened during the project or pre-termination, small issues, and how has that helped the parties? Just nipping a small issue in the bud and preventing it from getting larger.
I've got two ongoing FIDIC arbitrations where the project is still live, and the reason that's happened is that a party wants to reverse the decision of the dispute board, where a decision is going to come up, where a matter is going to come up again and again and again during the project. So it relates to the interpretation of a contractual provision, which is unfavorable to the other side. So they're taking that to arbitration because they think it's going to come up during the currency of the project. So it does happen, but because arbitrations are so all-consuming and because they take people's energies away from the project, my experience is people tend to hold off until generally until the final account, really.
Yeah. Thanks very much, John. I think, those are the questions that I had. There's a third question that comes from me personally, but that's which arbitral seats make for the best holiday destinations?
Well,
if
London's not good for a holiday, but it's good for going to other places that are good for a holiday.
If I can interject on the streamlining of an arbitration in terms of time.
Yes.
I was involved in an arbitration of FIDIC Red Book. After a termination, there was a sole arbitrator who happened to come from Keating, Dr. Robert Gateskill.
Yeah.
And because there was a termination, which the contractor had brought about and was successful, there was a rather large final account to be agreed. And I think there was something like 2,000 items in question and debate at that stage. So Dr. Gateskill suggested that the parties appoint a joint expert. And I was fortunate enough to be appointed. And then rather than what the contractor wanted, which was a little bit of a bluff to try and get a settlement, he wanted a hearing to go through every single item in dispute, measurement, variations, plus the claims. Dr. Gateskill made an order that the joint expert, me and my team, as he put it, would have a period of 3 months to sit down with the parties and agree as much as possible. So if you like, we acted as quasi-mediators, and one guy was delegated to go and talk about quantum, one guy was delegated to talk about time, and I visited, because it was outside of UK, it was in the West Indies, and I visited once a month to wrap up the agreements, and it worked. It was 100% successful on the measured work and variation items, such that when we actually got to the tribunal, we had a signed piece of paper from both parties, and the hearing had, there we go, there's the measured work and variations. All we have to deal with now is the claims, the real contentious matters. And that must have taken, well, the contractor wanted a hearing of some 7 months or something, which nobody ever would do, not to go through a variation worth, £100 here and £200 there, or whatever it was in dollars. But that was an excellent idea from Robert Gateskill, and it worked.
Thanks, Paul. That was very interesting, and thanks for that anecdote. Thanks also, John, once again for your presentation. We break again for 10 minutes, after which we return and hear from Paul on practical considerations in navigating through disputes. Thank you.
Okay, everyone. Here we are, the last session of the last one. So if you haven't all switched off because it's me again, here we go. I'll share my screen. I'll hopefully share my screen anyway. I don't know why that's going like that, but anyway. Hopefully you can all see the screen and it's fine. Now, as Jatan said in my bio, I've been a consultant, expert witness, and so on. Now, this is very much as a consultant. Many of my clients are contractors. Most of my clients are contractors, in fact. And very often we've gone through the phases of trying to settle at site level. We've had discussions with the engineer and so on, and we cannot get an agreement. And they've said to me, okay, fine, what do we do now? What do we do? It's the contract says, let's go to dispute board, but what does that mean? What are the problems? And if we can't agree, what happens if we go to arbitration? John alluded to the fact that it's perhaps a long and painful process for everyone. And I think we try to do in both employers' claims and contractors' claims, breed a situation where we can't let the other side cannot afford to say no. That was a phrase that I think I used in both of those talks. So at site level, you're trying to prepare documents where the engineer cannot afford to say no, because the engineer doesn't want to go to arbitration, or the employer doesn't want to go to arbitration, or even dispute boards. So we've gone past that, however. They've allowed it to get to the stage where the contractor says, this is my only last resort. So we're going towards our dispute board or an arbitration. So here we go, some practical advice based upon my experience, which, as you can tell by my lack of hair, is quite a long time. So I've just got a problem with my screen at the moment. I want to try and move that over there. Thank you. That's it. So what do we know as a backdrop? If we do go to dispute boards, the Dispute Resolution Board Foundation, an American organization that has its own rules and trains a lot of dispute board members, they say that almost 85% or over 85% of dispute boards are successful. That means in their terms, they get to a decision and the decision does not go on to arbitration. So that's worth noting. Now, disputes are on the increase. Arbitrations are on the increase. The latest ICC statistics that I could find were 2021. And that suggested, and this is an increasing trend in terms of construction, that 26.2% of all arbitrations, a total of 840, were construction-based arbitrations. Now, they also have another sector called energy. Now, I would imagine that most of the energy disputes are tariff-related or whatever, something like this. But we don't know, and that's suggested from a friend of mine in the ICC, that maybe they put some of the energy disputes where it's a power plant construction or an off-take cables or whatever to the grid, they put those into the energy rather than construction. And that's another 18%. So it's a fair bet that perhaps we're over 30% or whatever of all ICC arbitrations are construction related. Now that's a rather large number for all of us to earn some money from as the lawyers and consultants and expert witnesses. And I've just said, this is the situation where we are now going to a formal dispute resolution procedure. We're taking it away from the site. It's perhaps the last chance to make an agreement, although, as I say there, always have settlement in mind. Just because you go to a DAB or an arbitration, it doesn't mean to say you as the employer or you as the contractor shouldn't be trying to find a way to end this painful, expensive procedure. And think of determinations. Even clause 355, there is the discussions between, or should be discussions between the engineer, the employer, and the contractor, a sort of mediation. And I think that role is enhanced, if you like, in the 2017 edition. And as John said in settlement, the amicable settlement procedures of 20.5, it's a sort of mediation. I've actually been involved in one amicable settlement procedure where they actually brought a mediator in. They felt that they were close enough not to press the button on the expensive, time-consuming arbitration that would follow. And it worked. And a mediator was brought in, and they settled at the 20.5 stage. So what else should we understand? We've missed out on settlement at site, but there's reasons why we haven't perhaps, but a dispute board in the first instance, an arbitration tribunal in the second instance, is not a panacea. It's not a panacea that's caused by poor design, either by the engineer, predominantly in a red book, or by the contractor, predominantly in the silver and the yellow books. It's not a panacea for the employer who's got an adequate budget and there says, well, I'm not going to pay you. I haven't got any money. I haven't got any money in my budget. Just take me wherever you want. It's not a panacea for that. It's not a panacea for the employer that says, I just need somebody else to make a decision for me. It's not a panacea for the contractor who's got an inadequate price to say, well, I'm going to go to DAB, I'm going to go to arbitration so that I can get my price increased, hopefully by someone making a decision in my favor. It's not a panacea for poor performance or unfulfilled obligations. Everyone should realize that within the FIDIC contracts, there is the obligations defined to both parties and performance defined by both parties. Just because you haven't done that, it's not a reason to go to dispute or go to a DAB or whatever. The DAB and the tribunal will recognize only entitlements. None of these problems that you may have. It's got to be the entitlements that you are due and nothing else. Again, the backdrop, and I think John alluded to this as well, a project may last for many years. A power plant may take 4, 5, 6 years to construct. The DAB has 84 days to decide. An arbitral tribunal has relatively few days to decide once they're in a hearing. I think John said one a week. The most recent one I did had a 1 week hearing, then a 4 week hearing, and then the tribunal actually called us back for another 3 or 4 days after they'd started making their drafting their award, because they felt there were some items where they were not totally clear upon. So they called us back for a third hearing. But if you think those time periods are minuscule in respect of the time it's taken to construct that power plant, 4, 5, 6 years. So if you have to try and convince a DAB 1 or 3 or tribunal 1 or 3 of your case within those minuscule time periods compared to what went on, and the item of dispute may have been running for a year, 2 years, or it may be a very short item of dispute, but majority of disputes relate to matters that have run on and on through the course of the project. So meticulous planning from the beginning of every stage of the arbitration or dispute board procedure is necessary. Some people say the first shot is your best shot, so the pleadings, if it is that's the pleadings or the memorials, and as an aside, as an expert, memorials I do not like because you haven't got all the detailed evidence from everywhere else when you're asked to do your opinion, an aside, but if you need that first shot is best shot mentality, you must prepare or prepare to fail. You've got to convince the tribunal in a relatively short time of your case or your defense to the other person's case, as the case may be. Now, the most critical thing when I'm talking to my clients about an arbitration or dispute board is that we are now handing over the decision-making process to somebody else. We have lost control unless we make an agreement, a settlement on the side. We are now saying, right, arbitrators, the dispute board members, you take notice of what we say in this relatively short period of time compared to the length of the project, and you decide for us. We cannot make that decision between ourselves. And as John said, be prepared for a possible long and expensive arm wrestle. Again, just an aside, one arbitration I was involved with, it took, let me think, it took like 3.5 years or so from start to finish. My client seconded 2 people from the project into the arbitration team. When that was over, some 3 years plus afterwards, they'd both lost their jobs. Their jobs had been allocated to other people. The company had shrunk a little bit. So the company was in a situation where it was looking for savings, and they said, sorry, John, sorry, Abdul. Well, we've given your jobs to Tom and Dick, and there's nothing here for you. We're going to have to make you redundant. It's just an awful side effect of that long and expensive arm wrestle. Again, time. John mentioned the time. Whoops, sorry. John mentioned the time. Now, this is from the FIDIC 1999 and the FIDIC 2017. Just how long does it actually take you to get to arbitration if the recommended time periods are actually adhered to by the parties? From the time you give the notice of a claim to the engineer under clause 20.1 in FIDIC 1999, it's 250 days, almost 10 months before you get to an arbitration, 8-10 months before you get to an arbitration. And that is the period for claim submission, the engineer's determination, the period for decision, the time to issue a non-objection, a notice of dissatisfaction, amicable settlement period, and then they'll give a request for arbitration. 252 days length of time, a good time to make a settlement between you two. Or FIDIC 2017, it's approximately 378 days if you add up the similar periods. Some people say FIDIC 2017 is a better contract. In this respect, you can look at it 2 ways. It's 370 days plus to come to a settlement, agree amongst yourselves before you lose control, or it's a long time if you believe from when you start the process that the engineer will never come to see sense, and you're going to have to go to formal dispute resolution in the form of an arbitration. Then, how long is an arbitration? I think the longest one I was involved with is something like 5 years. I'm sure it'd be interesting to hear what John and Abdul's figures are, how long an arbitration was, but it's nothing defined. It can be very short, it can be very long, very time consuming, as we keep saying, and obviously very expensive. So that's a little bit of backdrop. Now, a few more practical notes of what you should be considering before commencing. Nobody should go into an arbitration or dispute board without knowledge, what to expect, how to behave, and so on. Those of you that were on the previous courses that I delivered in this series will have seen my 3 hurdles. And I suggest that you just, even at this stage, you recall the 3 hurdles when you have an honesty session. I make all of my clients have an honesty session, and I chair that honesty session very often. And this is where you sit down with the people and say, okay, you realize what's going to happen. Let's just sit back. Are we really ready for this? Do we really want it to happen? Have we got a very strong case? Let's review what we've put down on paper before we press this button. Have we got that entitlement in the law or the contract? Have we got then enough records to convince the third parties? We are not trying to convince an engineer who has been on the site, understands what the site problems were, subconsciously will know whether he thinks he is right or wrong with his own decisions, but he will know what has been happening at site. The DAB, if it's not a standing DAB, will not have that benefit. The tribunal certainly will not have that benefit of being on site and understanding. As I said a minute ago, you have to convince the tribunal or the DAB in a very short period of time compared to the time where the problem was taking to manifest itself and actually get to the stage of dispute. For the first time, perhaps, you bring in witnesses of fact. Are your witnesses of fact, if they're going to be cross-examined, reliable, available? if you're looking at the period of time, take the bad situation, if you like. We're going to an arbitration. Will your witnesses of fact still be within the company a year, 18 months or so after you press that arbitration button? Will they still be around? Have they moved on? Have they gone to different continents? I've been involved in arbitrations where we've had to fly somebody in from Asia to the West Indies, and we had to persuade their employer to let them go at that stage. Will they be knowledgeable? Are they really the right people to convince that tribunal of what actually happened at site? And remember, in this honesty session, just why couldn't you reach agreement? Is it just the fact that you're all human beings and it became personal? Was it a loss of pride or arrogance by one side or the other side? Is it somebody in your own organization saying, I really don't want to say I was wrong. If I say I'm wrong, then the walls will come tumbling down on my world, but let's go to the third party for them to make a decision. Is it the employer perhaps who cannot make a decision to say, yes, the contractor is due some money for political reasons, or political reasons with a big P or small p, whatever you like. Some government departments, especially where I've been involved in Latin America, hold officers of government personally responsible for problems as they are perceived. And maybe a problem is paying a contractor a lot of money outside the contract price and giving a lot of time beyond the contract period, time for completion. I was involved in an arbitration in Italy, which was very close to Naples. We had 5 arbitrations on exactly the same topic. After the first arbitration, which we won, I was a parties expert in that. I went to the other parties expert, and who was the project manager for the project. And I said to him, hey, we're going to get this situation again. Hopefully with this as a backdrop, you can award us the time and award us the money. And he looked at me and said, Paul, this is Naples. This is the land of the mafia. If I give you time and money, even if I know you're entitled to it, somebody will be asking to look at my bank account. So I have to go to a third party to get that decision made for me. And perhaps on contractors, many contractors take income into their accounts before that income is realized. And there is pressure from the upper management that that income must be realized through an arbitration, rather than what is really an entitlement. And perhaps for the first time, the word counterclaim will come into your jurisdiction. Counterclaims arrive with arbitrations which perhaps aren't thought of at site level by the employer if you're a contractor. They will be scraping everything up and saying, hey, come on, if it's FIDIC 1999, perhaps there's a notice problem, perhaps there isn't. But counterclaims will arrive. Will they be bigger than you thought? Will they destroy your claims in terms of value? Who knows? But you must think of all these things in what I suggest is what I call the honesty session. Going towards, let's take the extreme again. Let's go in towards an arbitration. You must prepare a business plan. I tell my clients, you must have a business plan. Don't go into this blindfolded by expecting a nice result at the end with no thoughts about how much it's going to cost or whatever. And in this business plan, which hopefully the business plan will say, yes, and we're going to have a profit at the end, that's why do it. There's the cost of the proceedings. You should be talking to lawyers by this stage, and you should be getting to them fee proposals or fee estimates or lump sums as becomes more and more popular. I'm not quite certain how a lawyer can do a good job, and the same goes for experts. If you put a harness around them and say you're only going to be able to spend this, when you get to that stage, stop. Experts, especially if they're going to be working on behalf of the tribunal, but that's another topic. The internal costs and disruption. As I said, my 2 good friends from this arbitration who both lost their jobs, it will be disruption. It will be disruption to the working processes of the company if you're going to pull people away from their new projects, which may be going very, very well, but you're going to take a project manager out for a month here, you're going to take an engineer out for a month here. And all of this will have an impact on cash flow. Every good business plan has a cash flow forecast. and the cash flow forecasts for a major arbitration can be enormous. And then, again, and aside from the honesty session, what is the likely decision or award? What is the percentage of success you really think you're going to have? And maybe, depending upon what that percentage success is, what might a cost award look like? Will you get back your costs, a portion of your costs, or will, if you're not that good at what you've done, will you end up paying the other side's costs? And again, I've another instance of recall why the claim was made in the first instance. Is it a real entitlement, or was it a bluff to reach a commercial settlement? The arbitration I mentioned, where I was the parties joint expert, that contractor made a lot of bluff to try and get to a commercial settlement. It didn't work, and we had to go to arbitration, and I think the arbitrator actually awarded less than had been certified at the time of the termination. Take all of this into account on the cash flow and the honesty session, and maybe somebody's got to swallow a lot of pride and say, we do not go forward. The chances of us getting X amount of money is going to cost us X times 2 or X times 3 to do this. This is not business sense. Pride must be swallowed and management must be faced. John and Abdul have both mentioned rules. It's like any game, when you're playing cricket, whether you're playing football, whether you're playing rugby, there is a rule book, and you should not commence that game without understanding the rule book, your obligations, and the timescales. For those of you that like cricket, I believe that England are doing quite well at the moment against Australia. When I last looked for the break, I think there were 7 wickets down. So yes, know your rules, know your obligations, know your timescales. Know the dispute board or the arbitration tribunal. At the instigation of either, you have the chance to propose a member of a dispute board or a member of an arbitral tribunal. You should consider who is appropriate for the project. If we take it into dispute boards, it's more likely that you will have a technical dispute or a time dispute, and maybe not so much of a legal dispute. Therefore, I think most of the dispute boards that I see will very often be 2 technical people and one, perhaps perhaps a lawyer as the chair, just to keep the thing legal and above board in that respect. If it's a arbitration tribunal, and I've put a bullet point there, does it matter if you're claiming or defending? Obviously, the claimant puts the person down first. The defendant then has a chance to review, if we're talking about arbitration, to review who the claimant put forward as their arbitration pick. An instance, an arbitration I was involved with, 2 European contractors, but under English law. And the contractor who was taking it was a civils contractor taking a EPC contractor. Their pick was a civil code lawyer, a partner of a very well-known firm. And we sat back and we said, well, that's an interesting choice. It's under English law, but this guy probably doesn't know very much about English law at all. But then we decided that if we looked at the case of the contractor, the subcontractor, that their case wasn't that strong. Their case, they hadn't submitted notices. There are a lot of unsupported claims. There was not the records to back up their claims. So we decided that their choice was perhaps a civil code lawyer who was perhaps more easily persuaded on the grounds of reasonableness. Yes, there was definitely a problem there, and it must have caused them some issues. I think it should be some money for them. We decided to fight that. So we went for the term, I think John and Abdul will say, a black book lawyer. We went for a QC in those days, a QC who would look at the contract and say, they haven't done their notices, therefore the matter's dead. And it was an interesting selection. It's a discussion that I've had many, many times when you are trying to decide what sort of person you should have as your pick as an arbitrator. So once you've got this pick over, choose a good team to guide and lead you. Do not skimp on lawyers and external consultants or experts or whatever. Only we are trained for what's coming. You, as a client who's never been to an arbitration or dispute board in the past, will not know what to expect and will have some nasty, nasty surprises. So have to surround yourself with people who are experts in what they do. Keating Chambers is probably, in my view, the leading construction chambers, and they are ideally suited to guide you through such a process. Back to a little bit more on the witnesses of fact. The witnesses of fact back up the contemporaneous records. Where before, perhaps you were just looking at pieces of paper with the engineer, you know you're going to have somebody to go in the witness box and put his hand on his heart or her hand on her heart and say, this is what happened. The period of time between the event and getting into that witness box, memories will fade. When you start the arbitration, if it is an arbitration, get your witnesses of fact on board early, get them to write down their story very, very early, and get them all together such that they can make sure that they all have the same memory. No doubt the other side's memories will differ, so it will be are they credible? Have they told the truth? Don't persuade them to tell something that's not truthful, but memories will fade, and make sure that your witnesses are well practiced, well rehearsed. In London, there's a company called Bond Solon, and they actually offer training to witnesses of fact, how to behave in the witness box, how to respect the tribunal, how to respect the cross-examining barrister, and so on. Experts, if we go to experts, are more and more common in dispute boards. Most certainly they will be appointed in arbitration. And let's remember, experts are independent. Their duty is not to the party that pays the bills. Their duty is to help the tribunal come up with the right decision. They are not hired guns. And if they're a hired gun, 9 times out of 10, they'll be found out. And there's nothing worse than having an expert witness who is a hired gun, who has been persuaded by the instructing lawyers or persuaded by his employer to support their case rather than being independent. Once the tribunal have a thought that this is what's going on, it is detrimental to the case. Experts should know when to say no. The lawyer's duty is to push them towards support. The expert's duty is to know when to say no, this is my opinion, and so on. I'll put a note there, the consultant expert. Personally, this is my favorite role. I prefer to be a consultant expert than the independent expert. The consultant expert is another, in my view, way to streamline matters. The consultant expert can be appointed very early on in the proceedings and can help the legal team and the employer, contractor, whoever, to put together a very precise case. The role I've taken many times is to prepare the documents for the expert before the expert's appointed. And it just streamlines things, because there's nothing worse than having an expert appointed later on in the proceedings, perhaps after the pleadings have been drafted, when the expert doesn't support your pleadings. That leads to a thing perhaps sometimes called expert witness shopping, where the lawyers then perhaps look round for another expert who might support those proceedings. But if you're thinking very proactively earlier on, you can get a consultant in to look at what you say, and then before the expert's appointed, you've got your documents ready to be able to support the expert, so you're all in singing off the same page. It's a much more interesting role for me as a quantum person than actually being a quantum expert, which can be a little bit more like an auditor ticking files and saying this has been paid or not. Coming towards the end, reflections after an arbitration. Some of you may have been to the old IDRC, the International Dispute Resolution Centre in London in Fleet Street, which has now been demolished, and they've moved up to a really nice building near St. Paul's. This was some pictures I took during an arbitration, and you can see the volumes of documents. Those behind the 3 chairs at the top belong to the arbitrators. Then obviously on either side, there is the documents that either party had. In this arbitration, the other side had 9 lawyers. We had 3. There were experts, I think, from 4 different disciplines. There were members of the client's teams from both sides. They didn't have the claiming party. I was working for the respondent, did not have a good time at arbitration. They were awarded something like 12% of the amount claimed, but it cost them 30% to get that 12%. The respondent, our side, had made offers before and during the proceedings, well in excess of that 12%. And our costs, because we were lean and mean and well organized, we were only about 8% of the amount claimed. With those figures in front of you, I don't think I need to say to you that it was not necessary to have a cost hearing, and the negotiations that went to, if you can call them negotiations, to talk about costs, the respondent made a gesture towards the other side for their costs and said, thank you very much. It was a very time-consuming 3 years plus arbitration, and you didn't get very much out of it at all. In fact, you got absolutely nothing. You got a minus figure. Another reflection, maybe most of you will recognize Emma Raducanu, who was a qualifier in the US Open tennis a couple of years ago, and she went through to win the thing. Since then, she's had a pretty torrid time and quite a few upsets, and mostly through injuries. I put this slide down because awards can surprise you. I worked on one arbitration which was between a general contractor and a technical subcontractor, where the technical equipment failed to meet its standards. It was a flue gas desulfurization plant where the flue gas had to be desulfured to a level of 95%, and it only reached 92% or something. So solutions were found, but those solutions cost the employer a lot of money. The contractor paid for the technical part, but the power to generate these extra pumps and supplies of water and so on were costly towards the employer. So as main contractor, we had an abatement issue. And that abatement issue, we had something like £6 million removed from our final account, which logic says this is passable straight down to the subcontractor. We had as one of our witnesses, a witness of fact, the project director for the employer, who confirmed that we had had £6 million deducted from our account. Great, we thought. But when we read the hearing, the tribunal acknowledged the fact that that £6 million was deducted, but did not take £6 million into account. They took a far lesser figure. So whilst you think it may be going great, there will be some surprises, and in this case, a little bit of an upset. And that is, I think, is the end of my little talk. I thank you once more. Depending how the discussion's got, I've got some more slides perhaps that we could discuss on a different topic. Let's just see how the questions are going. Thank you very, very much for listening.
Thanks, Paul. Thanks, Paul. Insightful as always. So, Paul, there's just one question, and after that we can move to the additional slides that you had. The question is essentially to the point of, when claims aren't real claims, arbitration is used as a means of pressuring a party into a settlement, right? So I think the question is, how do you see that coming for one, and what are your tips to deal with it? So, for example, making sure that you get an arbitrator that is a bit stronger as opposed to someone that might be more accommodating. So, if you have any tips to fight these kind of tactics.
I think if you should understand your case. If we go back to the civil subcontractor, their case was not strong. They chose an arbitrator they thought that would support their case on a sort of fair and reasonable basis, we chose a black book QC. There's no great tips I don't think I've got. I don't know if Abdul or John have got any thoughts on that.
I think it's always difficult when you're faced with what essentially the sham claim. You're going to have to spend money proving it's a sham. But on the other hand, the person who is making the sham claim is making a huge bet that his bluff won't be called. If his bluff is called, then he's going to be on the receiving end of a loss in an arbitration and a huge cost bill. On the question of the choice of arbitrator, I think it's important to make sure that you pick somebody that's suitable. I've seen parties be tempted to pick somebody who they think is on side or who they know will be on side on the assumption that, well, that's going to help their case. Very often, if you pick somebody that's overly partisan, all that ends up happening is that the other two, if it's a three-man tribunal, assuming a three-man tribunal, just ignore that person. So it doesn't make sense for you to, I think you've got to be very careful about who you choose and make sure that person has credibility rather than picking somebody that you think is going to be on your side.
Just one other war story on selections of arbitrators. The one arbitration I worked on lasted 4 years, and that was because the two wingmen decided that they needed a lawyer as the chair. These were two engineers. They decided they needed a lawyer as chair, and in my view, they made the gross error of selecting a sitting judge. So the arbitration could only ever take place when the courts were in recess. And the lawyer for the government, who were always going to be on the losing side, was a very good exponent at postponing things. He used sickness, he used the law of 1810 of the country said if you're claiming something over 10 rupees, then you're going to have to make a document for that, which was totally disproportionate, but that law still stood. So this arbitration dragged on and on and on, and we had no end of postponements. So it's not just perhaps the wingmen that you have to be considered. I've never seen that again. I don't know if either of you ever seen it, but I think it's a rarity, and I would hope for it was never happen again.
Yeah, thanks, Paul. Paul, you did mention that you have some additional slides which I understand deal with publicity as a factor in commencing proceedings or not. Why don't you tell us about that? And then after we get to that, I did have some questions about what you just said, dealing with governments as a party.
Okay, this has become a little bit of a hobby horse of mine, I'm afraid. John mentioned whether or not arbitrations are private or not, and he gave good reasons why some arbitrations are not private. But of late, the ICC have joined up with an organization called Just Monday. And these are publicity things from the ICC or Just Monday. And it's we, the ICC, make arbitration awards available free of charge to the global legal community, thanks to our unique partnership. And it goes on that the reasoning that they decided to do this, or the public reason they decided to do this, was to improve transparency for the common good, so that arbitrations perhaps could be used more as a precedent. And there's other side things that Just Monday is an organization where you can look at the history of any tribunal members if the cases are publicized. So you can then read the decisions of that tribunal member. Let's pretend it was a sole arbitration tribunal member. You can see how they operated or whatever. And it's suggesting that they can rate tribunal members. If an award is published, then it also gives you access to comments about the lawyers, the barristers or the advocates, solicitors, and the experts, which is where I really don't like it. They say hopefully it's going to be welcomed by the community, but you know, I'm old. When I went to college, you know, there was the distinction: litigation is public, arbitration is private, and that was very much an attraction for people to sign up to arbitration agreements rather than go to the courts. And I just wondered whether in anyone's can put it into the question whether parties are really aware that these awards may be made public. I think there's some sort of opt-out clause somewhere in the notes for parties going to. And I'm just some questions. Does publicity affect the decisions to commence proceedings? Maybe again with the bluff claims, it might affect if someone says, I don't want this publicity that my company's gone there and actually been hammered by an arbitration award. Does it affect the manner of proceedings? As I said, arbitrators and lawyers may be ranked by organizations like Just Monday. And from where I go, nobody tells the expert. Nobody tells the expert that you are going to be subject to a public award. It will not make anything different in the way an expert should act. But I think John and Abdul will support me when I say that some of the judges in the TCC in London have perhaps been overzealous in their criticisms of experts. And I can name you quite a few experts who have had to leave the country because no one will employ them because they've made a mistake, or it's mostly delay people. Their evidence wasn't very good or whatever. And there's a suggestion from Just Monday now that experts may be ranked. Now, there's two people or two parties go into an arbitration that cannot agree. If we take an extreme and one is completely right and one is completely wrong, then an expert, especially perhaps a quantum expert, is being asked to make an opinion on somebody with very poor records. He may make an opinion on those records and say it's a range of 10 to 20 or whatever it might be. But that expert has a poor hand of cards. I've actually seen one of these publicized awards where the expert for the winning party was said, oh, this is fantastic, you've destroyed these people's cases. And the expert for the losing party, who did the very best it had with the cards in his hand, was criticized. And I just don't think that's very equitable towards expert. This is obviously an expert talking, but I don't think it's such a good thing to have complete publicity of awards. And I'll throw that open to John and Abdul and the rest of you for your comments on that.
I see dangers with some aspects of publicity of awards, but I also see benefits. In 2016, a former Supreme Court judge called Lord Thomas gave a talk about arbitration. And he said that one effect of arbitration had been to remove much cutting-edge commercial disputes from the English courts. So the English law had ossified to a certain extent and wasn't brought on in the same way as it had been previously, because so many disputes are going to arbitration. And when we're talking about, for instance, FIDIC contracts, there are huge numbers of decisions every year on how these contracts operate. And we see a small fraction of that. And I do feel that some increased publicity of awards could help arbitration develop a body of law that could be referred to, and that would help us all in using these contracts and in developing the law so it's fit for the modern world. But I don't think it should be done over the objections of the parties. I don't think it should be done if an arbitration has a confidentiality clause. I don't like the idea of ranking. And in a more general sense, I certainly think that arbitrators and judges should consider the effect of their words before they criticize experts. And I think in some respects, and for many reasons, I don't think the legal process necessarily serves experts very well. But yes, I certainly agree that people should be careful before criticizing experts when it can have such drastic effects on their careers.
I think on the issue of publicizing awards, I think I kind of fall somewhere between your position, Paul, and John. I'm sort of a traditionalist in the sense that, you know, as like you, Paul, I mean, I came up in this in a world where arbitration was confidential. Parties chose it knowing full well it's confidential. And I am a little bit skeptical about this argument about arbitral awards, forming precedents. The problem we have with that is that, there's such a large scope of possibilities when you're dealing with, take a FIDIC contract. A particular clause can be interpreted within a civil law jurisdiction, within a common law jurisdiction, different countries. The laws of the contract are going to have an impact on how the tribunal approaches interpreting that particular clause. So I'm not entirely convinced about the argument that we need a body of arbitral decisions that are going to serve as precedent. But on the other hand, I can see that there's a logic in where parties are willing to have their awards publicized and properly anonymized, so you can preserve confidentiality. Then I think yes, we may be served by it, but I'm very cautious about going down that road, to be perfectly honest.
I think Just Monday prefer not to have the awards anonymized. I would be happier if the awards were anonymized, but if you go on the Just Monday site and you can search on your name, you might find a surprise to find that you're in an award somewhere without your knowledge. They've gone back in ages. I'm in their database. For a case that must have been 20 years ago. Barry Bridgman was a clerk at Keating when this case happened, because he introduced me to the lawyer. So it's quite a while ago. And yeah, I was quite surprised to find that had been placed on the Just Monday database. So yeah, it's a difficult subject. I can see where John's saying it'd be nice to have some guidance, or if not precedent, guidance as to how to interpret things. I don't know, again, if people are aware that the ICC have been using Chris Sapella from Whitening case, who many see as the daddy of the FIDIC 1999 suite. And I'm an immense fan of this gentleman, but they've been using him as a FIDIC observer and getting his opinion at the time of scrutiny to see if tribunals have been applying FIDIC correctly as he would apply it. That is now official. I think it's been unofficial for a number of years. And there is a growing body of people that think that may be an issue, that the tribunals are not making the awards. They're looking at Chris Sapella and saying, oh, well, maybe we should change that. You haven't done that quite right. So there's going to be some interesting case law, perhaps, of appeals to arbitration awards, because of Chris Sapella, who's the nicest possible man you could wish to meet.
I certainly don't think these things should be done by stealth. But I am more hopeful than perhaps either of you that by publicity, a body of at least guidance, if not law, can develop around arbitration. And the area where transparency has had most prominence in arbitration is investor-state arbitration.
Yeah.
Where very many more awards are published. And there is a body of law around that. And one of the shortcomings that Abdul mentioned doesn't apply there. Investor-state cases are all under international law, so there's not the problem of different legal systems. Nevertheless, it has introduced certain arbitration concepts into the English courts recently. So the English courts have started talking about admissibility, which is really an arbitration concept, which has been given legs in part through the publicity it's gained in investor-state cases. So I do think there is scope for developing the law in that way. And in fact, when the Arbitration Act was going through the English Parliament, Lord Wilberforce spoke in support of it in the House of Lords and said that one day, I hope that arbitration will have its own substantive law. And arbitration's never fulfilled that potential. And in part, it's because we don't know what arbitrators are deciding. So, Paul, I completely agree that this shouldn't happen by stealth, and it shouldn't be going back 20 years, such that what you thought you were agreeing to turns out not to have been what you were agreeing to at all. That does seem undesirable.
Indeed. Anyway, I'll close that one. Thank you for indulging me, Jatan.
Yes.
I think it is a fascinating topic, and I think it is a topic that's going to grow in discussions. as people become more aware of Just Monday and so on. Thank you.
Thank you, everyone. Thank you, Paul. Thank you, John, and thank you, Abdul. And as this is the last session, the finale of the 6-month-long series, I would like to thank our audience, especially our repeat viewers and all those that have signed up for the sessions. I hope this has been exciting for you to watch, and all the sessions are uploaded to SCL India's YouTube page. So if you've missed a session, please go ahead and look at it if you would like to. And before bidding everyone good night, I would like to, of course, compliment SCL India on running this series and thank our supporters, which is Keating Chmabers, the driver group, and Khaitan for making this series happen, as also all the speakers and panelists that have joined us throughout these 6 sessions. Thank you, everyone.